Good morning. Thank you very much for the invite. For those of you who do not know me, I've been a member of the judiciary for the last 23 years. I was a magistrate for 22 years, and in these 22 years I have dealt with a lot of traffic cases and collision cases. I had weekly sittings for the misconception that the police don't do their duty and don't bring people to court. This is incorrect, because I could say that on a weekly basis I used to deal with about a minimum of 150 cases in the traffic sitting and a good 40 cases, collisions, on a weekly basis. So really the police did bring people to court. Whether it's enough is another issue which I will go through throughout my presentation. Today I'm in the appeals court, whereby I'm dealing with cases, once again, dealing with traffic offences decided by the magistrates' courts, and yes, they are certainly on the increase. I shall be talking about bringing to reality the laws which are enforced with regards to drink driving in Malta. I will go through also a number of amendments which have also taken place over the years. The national legislation, the main law regarding drink driving, is found in the Traffic Ordinance, Chapter 65 of the Laws of Malta. We also have a recent subsidiary legislation regarding the points, respective penalty points, which are given for people who are found drink driving, although this has its problems, which I will highlight later on. And we also make reference to the Highway Code, which, although is not part of our national legislation, a lot of court judgments make reference to the Highway Code. The breathalyzer test was introduced in Malta by Act 6 of 1998. However, the legislator has felt it necessary over the years to make relative and relevant amendments. The last amendment took place in 2017. What is the scope of the breathalyzer test? A lot of people think, is it really useful? Does it serve its purpose? And I would say that there are two measures. One, which is preventive. In other words, we try to stop people from drink driving or to reduce it if we don't manage to stop them. And there's also the scientific measure, to calculate the level of alcohol which is in excess to the prescribed limit. A definition, what we understand by unfit to drive. The law in Article 15A of Chapter 65 has given us a definition that no person shall drive, attempt to drive, or be in charge of a motor vehicle or other vehicle on a road or other public place after consuming much alcohol, that the proportion of it in his breath, alcohol, or urine exceeds the prescribed limit. A person is considered to be unfit to drive. His ability to drive properly is for the time being impaired. In other words, it is not only necessary that we have scientific results with regards to the consumption taken from a breath alcohol test, but also if the person appears to be unfit, in the sense he's got slurred speech, he's got a disfigured face, he doesn't walk straight, those are indications which show that the person has taken more alcohol than his body can take. The demeanor of the driver. For the purpose of this offense of drink driving, it is not only necessary that the prosecution prove that the driver was in excess, but also, as was held in a case decided by the Criminal Court of Appeal against Francis Patch, that one has to have a look at the physical condition of the driver. His slurred speech, he walks haphazardly, red in the face, he has a smell of alcohol, and this takes place many a time, because when the police stop you and they come to your window and they ask you to get out, straight away you start seeing the way they talk, the way they walk. From their attitude, you realize straight away whether the person has in actual fact consumed alcohol or not. Breath tests. Emphasis was taken, I understand, by the chairperson of the association with regards to the term reasonable suspicion. I think that really there seems to be a bit of a misconception, because although the term reasonable suspicion is a subjective term, in other words, it all depends upon the person taking the test, there are certain categories or certain guidelines which could be taken for the definition of when a reasonable suspicion sets in. Primarily, when a person is driving or attempting to drive on a road or a public place and has alcohol in his body. In other words, Therefore, it is not necessary that at that moment in time you are aware already that he has taken alcohol in excess of his prescribed limit. In other words, if you see that his disposition is one which indicates that he has taken alcohol, then that gives rise to a suspicion, a reasonable suspicion. And therefore, you can go forward and take a breath alcohol test record. If a person is driving or attempting to drive on a road or a public place with alcohol in his body, you know that, or you have seen him in a place, in a bar, drinking, and then you see him on the road, then that is a reasonable suspicion for you to take the breath alcohol test record. If he is, again, driving or attempting to drive on a road in a public place and has committed an offence against the traffic ordinance or any regulation made thereunder. Now, what does this mean? Under the traffic ordinance, we have the motor vehicle regulations, which has about 200 contraventions. So, if any person is on the road and has committed a contravention, irrespective of the type of contravention that has taken place, for example, he has skipped the continuous white lines, he has come out from red lights, he has started to drive haphazardly, he is driving slow on the outer lane, he has no lights on his car, he has, for example, the car is in bad condition. Any contravention which comes out from the motor vehicle regulation would warrant a reasonable suspicion for the police officer, and today with the community officer, to take a breath alcohol test record. Unfortunately, though, what is happening is that this term of breath test, this term of reasonable suspicion, in fact, has to be given a wider interpretation. And I think training and education should be given to the police officers and to the community officers who are on the road to be able to understand when actually they can step in. We also have another instance when a breath test alcohol can be taken, and this is in the case of a traffic accident. Now, as you will see with another slide which I will be bringing up, the amount of traffic accidents which take place every day, not necessarily fatal accidents, but traffic accidents, goes into thousands at the end of the year. So doesn't it warrant that a breath alcohol test record is taken? No, they're not taken, in actual fact. When I used to deal with the collision sittings, and I'm telling you, I used to deal with an average of 40 a week, and this is just me, I had other colleagues doing the same thing, I would get perhaps 1 or 2 accused of not having submitted or taken a breath alcohol test. Does it warrant more? Yes, I think that many more tests should be taken in this regard. The term reasonable suspicion. In fact, I made reference to a judgment which was given by the Criminal Court of Appeal, and here it said that biex jiġi radikat dan is-suspett raġonevoli l-uffiċjal konċernat jista' jieħu anke in konsiderazzjoni dak li qallu ħadd ieħor. For the benefit of our foreign guests, yeah, it means that for the reasonable suspicion to set in, the officer, public officer, can take into consideration any information which he would have acquired from other parties. For example, it could be that there is a collision and one of the drivers say, listen, I saw that he was drinking beer, which happens very often, and then the police officer goes and he sees an empty bottle of beer at the bottom of his car. That could be evidence to justify the fact that he had a reasonable suspicion to take a breath alcohol test record. Or, for example, they were involved in a car accident and somebody stops and says, yes, listen, he was in a bar drinking with us just until a few minutes ago. There again, although the police officer himself did not see him drink, it is enough reason for reasonable suspicion to set in to take the test record. The powers of arrest of the police. Because a lot of people say that perhaps the police abuse of this power, but such right comes out from the traffic ordinance itself, Article 15, and it says that as a result of a breath test, the police officer reasonably suspects that the proportion of alcohol in the driver's blood exceeds the prescribed limit, or the driver fails to provide a specimen of breath for a breath test when asked to do so, provided such person was warned that failure to take such a test is tantamount to an offence. In other words, in these two circumstances, the police are justified in arresting the person. You would say, is it a justification for something so small? Yes, it is, because at the end of the day, you have a life. I mean, if you're caught drink driving and you run over somebody, he can end up, paralyzed, or he can end up dead. So it is a justification for a person to be arrested. The problem which ensues is that a lot of people are brought to court and accused of not having given or submitted themselves to the breath alcohol test and are acquitted. And you'd probably say, what is the reason? The law makes it very clear that when you do take a breath test of an individual, you have to explain to them if they are refusing to take such test, the refusal in itself is tantamount to the crime being committed. In other words, if you do not submit yourself to the test when asked, you are found guilty. What happens is this, is that the second part of this provision, in other words, that you have to explain to the person that you are found guilty by not submitting yourself, is not being explained to the individual. So when the individual, the accused person, comes to court and he says, yes, I was cautioned, but I wasn't cautioned that the absence of my taking the test is tantamount to the offence itself. The caution that I was giving is that I have a right to remain silent, I have a right not to incriminate myself. And that is not the same caution which the law provides for you in this particular offence. The offence is a sui generis offence, and the failure to submit yourself to the test when asked, whether it is legitimate or not, amounts to the offence. You can contest it at a later stage, but there and then, the order given to you by the police officer has to be followed. The specimen analysis, there are 3 types, and the blood specimen and urine have to be taken in an approved laboratory. The specimen shall be taken as admissible as evidence in a court of law, and the presumption is that the analysis is correct until the contrary is proved. These were 3 analyses which were made in this judgment given by the Court of Appeal. Failure to provide a specimen. This is tantamount to an offence unless the contrary is proved. It shall be presumed that the proportion of alcohol in the person's blood exceeds the prescribed limit. As was held in this case, irid l-ewwel ikun hemm dan l-avviż f'dan is-sens mill-uffiċjal tal-Pulizija u minkejja dan l-avviż dak li jkun jibqa' jirrifjuta li jagħta test tan-nifs. In other words, that you have to inform the suspect at that moment in time that failure to submit yourself to the test is tantamount to the offence being committed. We do have another problem here in the sense that if a person decides to refuse to take this test, then we do not have the scientific result of the test. In other words, it is only presumed that he is in excess of the breath alcohol test. So the court is not, in its punishment, which we will speak at a later stage, is not obliged to suspend him from his license because we do not have a scientific test that he was in excess. We have the evidence that he has committed this offence, but not that he was in excess. So the discretion of the court sets in at that stage in the sense that although it is bound to impose the fine which the law provides, which is a multa or imprisonment, it is not bound, or it does not have to, order also the suspension of a license because we do not have the scientific test. So maybe that should be addressed as well through legislation. The defense, which can be brought up, a person can prove that his failure to give the sample was due to a physical or mental incapacity, or that such tests would entail a substantial risk to his health. For example, if you are being asked, this is just hypothetical, to give a blood test and the needle is not coming out from a plastic, so you're going to be, put at risk, your health is at risk, so you have a right to refuse, for example. Or if, for example, a person has breathing difficulties and is put on a machine and therefore does not breathe and therefore is not in a position to blow. I mean, what is important is that the reason for you to refuse to give this test is something independent to the person. In fact, as was held in Bonici case, trid teżisti indipendentement mill-anjensità dovuta għal fatt li dik il-persuna tkun involuta f'inċident automobilistiku. In other words, the fact that you are anxious because you are involved in a traffic accident is no reason for you to say that you do not want to submit yourself to a test. In another case, in the Claire Falson case, il-fatt li persuna ma tkunx tista' tonfoq tajjeb minħabba l-istat ta' tossifikazzjoni li tkun fiha jew minħabba l-istat ta' eċitament li jaħkimha tkun ħabtet jew għax tkun ġiet arrestata mill-pulizija ma jammontax għal inkapaċità fiżika. In other words, if the person is not in a position to breathe well on account of the state of intoxication, is no reason why that same person should not have submitted to the test. In other words, the failure to give a sample has to be something independent to the person himself. Where is the person held? So the detention of persons who are affected by alcohol or a drug. A person required to provide a specimen of breath, blood or urine may be detained by the police until it appears to the police that such person is fit to drive. In other words, that if it results that the person who gave a result is positive in excess of the prescribed limit, the police are justified in keeping the person with them until the state of detoxification goes by. And this naturally is done so that there will be more safety on the roads. The breath tests with the new introduction, which took place in 2017, can be carried out not only by the police, but also by community officers, known as wardens. In other words, community officers can ask a driver to give a breath sample for the same reasons explained earlier on to police officers. Should the driver fail to take a test, he may be forbidden to drive until the police officer arrives on the spot. If the driver keeps driving and ignores the requests of the community officer, such behavior is tantamount to an offence, as if the request was made by a public officer. And if the community officer has a reasonable suspicion that the proportion of alcohol in the blood exceeds the prescribed limit, he shall request the police on site and the driver will be forbidden to drive. This naturally is a good introduction, a good amendment which took place because, as you all know, there seems to be more community officers on the road than there are officers on the traffic, on the beat. The punishment, we have also seen an increase in punishment recently. For the first conviction, you can be punished with a multa of 1,800 euros, or to imprisonment not exceeding 6 months, or to both. Second conviction, or subsequent, you have 3,000 multa, imprisonment not exceeding 1 year, or to both. In addition, you have the disqualification from holding a driving license. In the first conviction, it's not less than 6 months. In the second conviction, not less than a year. Now, we also have this new amendment to the law. In other words, that although the law provides prescribed limits, which we'll probably see in the next slide, there is a leeway in the sense that besides the prescribed limit, there's also another 8 milligrams. In other words, if the prescribed limit is 35 grams per 100 milliliters, in actual fact, it's 43, because if you're caught with those parameters of the 8 milligrams which is in excess, then in that case, the court can not fine you. I don't think many people know about it, but it's there in the law itself. And also, the guilty person may be condemned to pay the expenses involved in taking of the tests. However, this I've never seen in these 23 years that I've been in court. Now, what happens if the accused person does not pay the fine? That is, upon a request made by the Director of Courts, that is converted into imprisonment. Just to let you know that 35 euros is equivalent to 1 day in prison. So if a person is fined 1,800 euros, he is actually going to be sent to like 51 days in prison. And once the conversion takes place, we cannot convert it back into a multa. So if the person is sent, an order to pay the fine and he ignores it, and we have an application and we convert it, then he has to do the 51 days in prison. Also, we might have also a problem here with regards to enforcement, because what happens is that if the court, and many a time it does, orders the suspension of a license, this is not notified to Transport Malta, and so Transport Malta are not aware of it. I was just talking to a representative of Transport Malta recently and told me, but we follow judgments. I said, yes, but you follow the judgments of the Court of Appeal, which are online. The court's judgments with regards to the traffic sitting and the collision sitting in the magistrates' courts are not online, and it is, in the majority of cases, suspension of licenses are taken in those sittings, and therefore, since there is no enforcement, one could say that it is really useless, because in actual fact, the 6 months suspension is as if it did not take effect. I would recommend that there is either some form of legislation whereby the court is bound to send its judgments to Transport Malta, so that Transport Malta can send for the guilty person and take his license or inform him about the consequences or whatnot. Driving offences, the codes and respective penalty points. Here again, we have the penalty points which could be inflicted with regards to driving or drug driving. But there again, how is this going to take place? How does Transport Malta get to know about the judgments which are given in court? So far, there's no liaising between Transport Malta and the court. So although in the legislation we do take points, in actual fact, I do not think that they're actually coming into force with regards to judgment convictions from the court. These are the prescribed limits. So you have 22 milligrams per 100 milliliters in the case of for case of driving or attempting to drive all cars. We also have a variance with regards to commercial cars or under a probationary driving license. These are the new amendments which took place. And also with regards to people who are driving or attempting to drive buses, coaches, or other vehicles carrying passengers, there's zero tolerance to drink driving. When we're talking about the prescribed limits with regards to the first two categories, one must not forget the 8 milligrams which I spoke of earlier on. A lot of people ask me whenever I'm socializing, and they tell you, but how do you know? If I take one drink or you take two drinks, it doesn't affect us the same. Yes, it's true. There are a lot of factors which have to be taken into consideration: the weight of a person, whether he's male or female, his age, his metabolism, his stress levels, the amount of food taken, but for the intake of alcohol, the type and percentage of alcohol, if it is accompanied with medication, if certain body organs are malfunctioning, like the liver, so naturally then you are less tolerant. So all these are factors which are taken into consideration when actually equating the prescribed limit, because it does not affect everybody the same. I mean, one drink on a thin person certainly has more effect than a person who might be chubby. This is what is provided for, just to give you an idea, in the law and the highway code, to see how the alcohol intoxicates the body. These are an indication of the road traffic accidents. In fatal accidents in 2017, we had 17, but with regards to involving injuries, we had 1,519, and simple injuries and government property, 2,216. The grand total of 3,752. This is just to give you an idea. And this excludes those bumper-to-bumper accidents. So in actual fact, when you look at it, we have a lot of traffic accidents taking place on a daily basis, a lot. And a very few tests are taken out. The proportion is practically non-existent. These are the breathalyzer tests which were taken in Malta in the period of 2015-2018. And there again, you could see, just to give you an example, in 2018, we had 165 tests taken. And if you were to look back, you say how many accidents took place? There were 3,742. Does it warrant such an explanation? Grounds why there are so many acquittals in court, because people think that the courts are not effective. Many a time, unfortunately, mistakes are carried out in the records itself, which are carried out by the police, in the sense if the input is not correct. We do have mistakes. We had, for example, only recently, I had a statement taken of an accused person, which was dated and had its time. The statement was taken at 8 o'clock in the morning. And then when the breath alcohol test was given to me, the time on the sheet was 9:15. So I said, how could the test be taken after the statement was given? There must have been something wrong. And then it transpired that the calibration on the machine of the breath alcohol was not correct. So there again, you get an acquittal. You get another time, for example, that the receipt has to be signed by the officer and the person submitted the test. And sometimes the officer forgets to sign the test. So you do not have the best evidence that that actual test pertains to that accused person. Or, for example, happens many a time that the number plate of the car is input wrongly into the machine. So when the test comes out, you have the charge saying the number plate is one thing, and on the test, the number plate is another. So there again, you have a conflict of interest. There are many reasons why we have acquittals. Unfortunately, a lot of these tests are not carried out with accuracy and they're not very thorough. So yes, we do get acquittals. For example, in this case, you see, this is of the Herrera case. This was a fatal accident. In il prove prodotto il alcohol test record huwa monk, ġifieri has something missing. U għalhekk m'għandux il-firma tal-operatur, the operator did not sign this document, and therefore there was no even evidence that it was taken in the laboratory. In the case of Aldo Fenek, again decided by the Court of Appeal, it's il-dokument mhux wieħed komplet. It is strange, in fact, how it was not complete. Therefore, the court felt that this document could have been alterated, and therefore this was not the best evidence, and therefore once again the accused person was found not guilty from this charge. Why it is important to educate people better with regards to the importance of not to drink drive. Any amount of alcohol can have a disastrous results on a driver. It reduces coordination, it slows down your reaction, it certainly reduces your field of vision, and it affects how you judge speed, distance, and risk. So my recommendation is to stay alive, don't drink and drive. Thank you very much.